So I created this presentation to guide our discussion. So we heard from the public, we heard from the panelists, and now we have to decide amongst ourselves. So this is a statutory analysis of the bill AB 3121 as written. That's also informed by legislative history and other factors. You can go to the next slide. So essentially, I'm making the argument that the legislative history of AB 3121 and by extension HR40 is inherently lineage specific, and then I'll point to actual statutory provisions that demonstrate that AB 3121 is lineage specific. Secretary Weber's legislative intent demonstrates a lineage specific intent. I'll also briefly go over the history of reparations advocacy as it pertains to the institution of slavery to demonstrate that that movement has been lineage specific. Also, U.S. constitutional law, as prescribed by the insight from Dr. Chemerinsky, demonstrates a lineage-specific model for reparations for the institution of slavery. And then I'll also talk a bit about international law, including the Genocide Convention and guarantees of non-repetition. And again, I have a Master of Laws from the University of Amsterdam on international criminal law. Next slide. So let's first talk about the legislative history. So oftentimes administrative law experts, when they want to figure out what exactly does a bill entail or what's its intended beneficiaries, they'll look at the legislative history. They'll see what was going on in the world during the time that the statute was enacted. So in order to first understand the legislative history and context about AB 3121, and I think Marcus Champion hinted at it, you have to start in 1988. When the Civil Liberties Act of 1988 was passed, which was a federal law that granted reparations to Japanese Americans who had been interned by the United States government during World War II. Because the law was restricted to American citizens and to legal permanent residents, ethnic Japanese who had been taken from their homes in Latin America, mostly from Peru, were not covered in the reparations, regardless of whether they had remained in the United States, had returned to Latin America, or had been deported to Japan after the war. Also, the white wives or spouses of these Japanese American internment victims were also not given repair. And if you talk to any Japanese American person who was a part of the redress campaign, they'll also state that HR40, which was initially introduced by John Conyers in the late 80s, was modeled after the lineage-specific Japanese American redress bill. So we'll move on to December 19, 1988, when Jesse Jackson held a press conference declaring that the Black community wanted to be considered African Americans and not Black, right? No later than a month after Jesse Jackson held that press release in December 1988, the late U.S. Congressman John Conyers introduces HR40. Again, no less than a month after Jesse Jackson's news conference, declaring that African American was the terminology that they wanted to use to prescribe to Black Americans descendants of chattel slavery. Also, it should be noted, according to official reports, over 50% of Caribbean foreign-born people in the United States arrived to the United States after 1990. At least 1 year after the late Congressman Conyers initially introduced HR40. Also, according to official reports, almost half of the African foreign-born population in the United States arrived after 2000, nearly 11 years after Congressman Conyers initially introduced HR40. Also, as Marcus Champion noted, AB 3121 is a carbon copy of HR40, but for the additional lineage-specific information or terminology that they introduced, which is a special consideration language, which Secretary Weber noted in the task force hearing in January, that they included that special consideration language to acknowledge the contributions of free Blacks and formerly enslaved Africans prior to both groups' official recognition of U.S. citizenship via the 14th Amendment. So essentially my argument is that HR40, which is the federal reparations bill, and by extension AB 3121 are lineage-specific bills. They do not include reference to Black Americans of immigrant origin by virtue of many missing key terms in the duty section and in the legislative findings and declarations section, including but not limited to Caribbean, West Indian, African foreign born, or even global Black diaspora, which is explicitly referred to in NARC's $3 million MacArthur Foundation grant. And other keywords that would infer that HR40 and AB3121 are intended to include any other group aside from the descendants of free Blacks and formerly enslaved Africans. Next slide. So next slide. So there's many statutory provisions that I cited, but in the interest of time, I'll just cite a few of them. So the first statutory provision I'll cite is the first legislative finding, which says more than 4 million Africans and their descendants were enslaved in the United States and the colonies that became the United States from 1619 to 1865 inclusive. So at the outset, the first finding in the statute outlines the intended agreed population, which is more than 4 million enslaved Africans and their descendants. So these people came to be known as American freedmen after March 3rd, 1865, when President Abraham Lincoln signed a bill creating the Bureau of Refugees, Freedmen, and Abandoned Lands. Known as the Freedmen's Bureau, this federal agency oversaw the difficult transition of African Americans or freed African slaves and their descendants as defined in the statute from slavery to freedom. Next slide. So that's an original picture from the U.S. Senate archives of President Abraham Lincoln signing the bill that created the Freedmen's Bureau. Next slide. The next provision that I want to talk about is in the duty section of AB 3121. It mandates the task force to document and examine facts related to the following: federal and state laws that discriminated against formerly enslaved Africans and their descendants who were deemed U.S. citizens from 1868 to present. So this statutory provision is lineage specific. It is mandating or requiring the task force to study and examine federal and state laws that discriminated against a particular and distinct group of people. Who are those people? Formerly enslaved Africans and their descendants, who are also described as African Americans or American freedmen as a distinct historical and political identifier, who were deemed U.S. citizens from 1868 to present, which implicitly refers to the 14th Amendment to the U.S. Constitution, which was ratified by U.S. Congress in 1868. This particular provision does not require the task force to document or examine discriminatory federal or state laws for any other group, and more particularly for any other group on the basis of race or skin color. Next slide. This corroborates with scholars like Martha S. Jones, who created the book Birthright Citizens, that talks about how African Americans, through learning and studying the law, securing allies, conducting themselves like citizens, argued that their birth on United States soil guaranteed their rights. So this book essentially shows how the 14th Amendment constitutionalized the birthright principle, fulfilling the long-held aspirations of African Americans. And that is why this particular statutory provision cites 1868 to acknowledge free Blacks and enslaved Africans all becoming citizens at one particular time, and that was in 1868 by virtue of the ratification of the 14th Amendment. Next slide. So again, I'm not going to go through all the statutory provisions, but there's a few more that I would like to hit on. The next point is about, no, we can move on. This is saying the same thing. Same thing. Next slide. Okay, wait, no, go back. This is what I want to talk about. So there has been a lot of conversation about in this task force about which groups are particularly impacted by the lingering negative effects of the institution of slavery. Is it the direct descendants of enslaved Africans in the United States, for instance, or is it all Black Californians by virtue of race or skin color? So this particular statutory provision in the duty section of the statute mandates the task force to study and document and examine facts related to the lingering negative effects of the institution of slavery and the matters described in this section, particularly on living African Americans who are descendants of persons enslaved in the United States, and on society in the United States. So this particular provision is lineage specific, And it's requiring that the task force study the lingering negative effects of slavery, specifically on a particular group of people. And the term society necessarily is race neutral. Next slide. Okay, again, this statutory provision states the same thing. The task force is required to study and develop reparations proposals for African Americans as a result of de jure and de facto discrimination against who? The statute verbatim is very clear and said against freed slaves and their descendants from the end of the Civil War to the present, including economic, political, educational, and social discrimination. So while this task force is mandated to study and develop reparations proposals for contemporary or present day harms, such as redlining, educational discrepancies, predatory financial practices, economic, political, educational, and social discrimination, the statute clearly outlines such recognition is limited to freed African slaves and their descendants who became citizens after the Civil War by virtue of the 14th Amendment. Next slide, please. We're going to move on. As I will bring one comment I want to say about this. There are some other slides in the presentation that talk about why the statute references the term living African Americans. Next slide. I'll discuss it afterwards. Next slide. Okay. This slide. Yes, this slide. Now, this is a statutory provision that talks about the apology that the task force has to draft. Right? And let's look at what it says verbatim. The task force shall address, among other issues, all of the following: how the state of California will offer a formal apology on behalf of the people of California for the perpetuation of gross human rights violations and crimes against humanity on African slaves and their descendants. So under international law, the apology is a symbolic form of reparations, and it governs the universe of the subsequent material reparations to follow. So this statutory provision is quite clear on who the state of California has to apologize to. It has to apologize to particularly African slaves and their descendants. This statutory provision is not requiring the task force to offer, or the California by virtue of the task force, to offer a formal apology on behalf of all Black Californians on the basis of race or skin color. It's requiring the task force to draft an apology for a specific crime against humanity on African slaves and their descendants, which are African Americans who descend from persons enslaved in the United States. Next slide. We will move on in the interest of time. Next slide. Again, the special consideration language, Dr. Shirley Weber came to speak and talked about how it was included to reference the contributions of free Black people and enslaved Black people. Next slide. That corroborates with history as well. The conventions of colored citizens of the state of California from 1855 to 1865, that was clearly before the abolition of slavery. There were free African Americans in this state fighting for citizenship rights because they were treated as second-class citizens because the 14th Amendment had yet to be enacted. Next slide. And then that's another picture from the California African American Museum of delegates representing 10 of California's 27 counties met at St. Andrew's African Methodist Episcopal Church in Sacramento for the first California Colored Convention.